Hello, good morning, everyone. It is day 14 of L2 construction series. Thank you for joining us on Sunday morning. And for those who celebrate Easter today, happy Easter. All right, as you can see, there's no guest today, just two of us, as we originally thought today would be one of our last sessions before MCO. Notwithstanding, we do hope that you will still be able to enjoy and benefit. Today's topic is discussion on CIPAA claim. Without further ado, I bring you Mr. CIPAA, Loon.
Thank you, Hong Kit. I never known myself to be a Mr. CIPAA, but to perhaps disappointment a lot of the audience today, I will not be speaking too much on this particular topic. I'm sure a lot of you would have attended my conferences in the past, and you might have had enough of me already. Today, we are segregating the topic into 4 sections. I'll be dealing with the first one, which is setting CIPAA process in motion. Then I'll pass the mic to Hong Kit, who will continue with the second section, which is on the initiation of the CIPAA proceedings. I will then talk about the powers and jurisdiction of adjudicator, how in certain circumstances that an adjudicator should be dealing with these 2 issues, jurisdiction and powers. And thereafter, the last section, which is on the delivery of decision and the aftermath, that will be dealt with by Hong Kit. If we still have time, then we will be addressing questions addressed by the audience. And it's Sunday, as Hong Kit has mentioned, and usually Sunday is slower compared to other days. Maybe during the weekdays, people feel obliged to be progressive, just like the usual working day, and try to learn more and be progressive. But still, we have more than 300 participants today, despite it's Easter. And thank you for your support. Without your support, we would not have gone so far. And this is day 14. Now, starting with CIPAA, setting CIPAA process in motion. Of course, the first thing that you have to do in order to set the CIPAA process in motion is to file or serve a payment claim. Now, there are certain items on the checklist which I've listed down here that you have to go through before you even file a payment claim. Now, of course, there are certain mandatory requirements, one of which is that there must be a construction contract in writing. Now, the courts have interpreted this term very liberally, not to say that it must be a full bound construction contract that you see in big volumes. There could be a simple letter of award, and that could be constituted as a contract in writing. It could be by way of correspondence. It could be in the form of invoices and purchase orders. And these documents, loose documents, have been interpreted to be legal construction contract in writing. Now, of course, the second mandatory requirement is that works must be within the territory of Malaysia, because CIPAA is meant to cater for construction projects in Malaysia. But it doesn't matter if the parties to the contract are foreigners, they are non-Malaysians, and that's fine with it. So long that the works are within the territory of Malaysia, whether partly or wholly. Partly because it would include, for example, the construction of gas piping that runs from the Malaysian shore to other countries like Singapore or Thailand or even to China. Then it would be cross-border, but it actually starts from Malaysia. Then it would still be considered as a construction work within the territory of Malaysia. Now, of course, the controversial issue is that how wide that the CIPAA legislation applies. There have been some controversial, but it's kind of settled now. It started off with the Yuda Holdings. I'm sure everyone agrees with it. That was the first case decided by the court on CIPAA, and I was representing the KLRCA, and then as also the friend of court in that matter, whereby the court had decided that the CIPAA was applied retrospectively. But this position had been going on for about 3.5 years to 4 years until it was finally overruled by the federal court last year. Now, of course, I was also involved in the federal court decision. I was defending the High Court decision in Yuda Holdings, but I failed. And the federal court has overruled that decision and said that CIPAA only applies post its commencement, which is the 15th of April 2014. So what that means is that if a construction contract was entered into prior to 15th of April 2014, the parties to the contract cannot then resort to CIPAA proceedings. Now, there are some controversy, there are some fine line, borderline cases, and it's interesting to see there are 2 cases recently decided by the High Court on this issue, whereby we involve a situation whereby a letter of award was signed before 15th of April 2015, right? Not 14, there's a typo error. LOA signed before 15th of April 2014. But then it was formalized after that date. Was it recognized? Now, there are 2 cases. In Princip Tech, the court held that it was a contract entered into prior, even though the contract was formalized later after the commencement of CIPAA. There was no change to the intent of the original letter of award, which was signed before 15th of April 2014, and therefore it fell outside CIPAA parameters, and therefore the decision was set aside. Now, in another case, and strangely, and not strangely, it's actually quite interesting to note that KLIAA was also decided by the same judge who decided in Princip Tech, but the judge decided to distinguish it from the previous decision. Now, what is the difference is that there was also a letter of award which was signed before 15th of April 2014, but then there was a formalization of an agreement which came later, just like Princip Tech. But the difference is that the court finds that in KLIA, the formalized agreement which came later has some alteration of certain conditions that were different from the original letter of award. And because of that, the court finds that there was actually a replacement contract. And because there was a replacement contract which fall within the parameters of CIPAA, because it came after 15th of April 2014, the court recognized the contract that falling within CIPAA, and the decision was upheld. Now, these are the 2 borderline cases where you can actually use it as a reference if you fall within this borderline situation. Now, of course, there's another development as well. Now, previously, we had judges like Datuk Mary Lim, we had Datuk Lee Swee Seng, who were very pro-CIPAA and interpret provisions very liberally. Now, of course, these 2 judges have been elevated to become Court of Appeal judges, and we have new judges coming in, and they have been differing positions. They have taken a more stringent approach in compliance, in terms of compliance with the actual provisions of CIPAA. What happens is that in order for a payment claim to be a valid payment claim, it must actually satisfy all the conditions set out in Section 5(2). Now, what are those conditions? Like, for example, you must actually expressly state the due date, the payment which you actually seek to apply for CIPAA. And not only that, you have to set out what is your course of action with relevant facts in place. If you fail to do that, the court will be ready to strike it down and say that it's too vague to be a Section 5 payment claim, especially if it is awarded in the form of a letter of demand without actually expressly mentioning that it is actually a payment claim issued under CIPAA. Without that express statement in your letter or a payment claim, then the court will be ready to say that it is not a payment claim within the meaning of Section 5 of the CIPAA Act. And what is the consequence of that? if there is a decision rendered under that circumstances, again, the decision will be struck out or dismissed or set aside. Now, another thing that you have to take note of is the service. As you know that we have a special provision, Section 38 of CIPAA, where it requires the document to be served via certain standard modes as set out in the provision. Now, you know, if you want to have other modes as apart from those provided in the provision, like email and fax, then you have to have an agreement or to show that there's an agreement between the parties that that would constitute a valid service as well. Otherwise, don't take the risk. Just follow the modes of services as set out clearly in Section 38, which would include service by registered post or leaving a copy at the last known address, or to serve it by hand within office hours. Next slide, please. Now, I've already talked about payment claim. Now, let's talk about payment response. If you are a non-paying party, having been served a payment claim, what should you do? Now, because of the Federal Court decision in View Esteem, which says that the service of payment response is not mandatory, which means you can actually keep your cards to your hearts and you only review what are your defenses during the proceedings by filing an adjudication response later. Now, is that correct or is that right? Now, technically, if you follow the Federal Court decision, there's nothing wrong for not replying or filing a payment response, even after you have been served a payment claim. But good practices dictate that you should do that. There are a few reasons. We have learned from our mistakes in the past. We took a very relaxed mode about Yuda Holdings. We thought that it was a set law which would not be changed later, but that has proven us wrong. There has been so many other cases that fall within that category as well, like the liquidated damages. You don't have to prove loss now. So that's the things is that law, just like anything else, can be changed. So you do not want to end up in a situation whereby in the future there is another Federal Court decision which says that payment response must be served and it's mandatory. And what happens if you don't do that? Now, that's why good practice, as I said, you should file a reply within the stipulated time as set out in the provision, which is 6 sub 1, 6 sub 2, and 6 sub 3. Now, of course, you can put up a reservation to say that you reserve the right to add, subtract, or even amend during the adjudication response after the commencement of the proceedings. That would be enough to reserve your rights to add on more things later during the proceedings. So that I would advise against not filing any payment response at all. As I said, law could change anytime. Now, the other thing is also that in putting up a response, you have to identify what are your set-offs, what are your counterclaims, right? You can actually raise whatever set-offs that you can, but it must be within the parameters of the contract. There must not be damages claim. There must be provisions which allow you to launch the set-off to deduct the sum that is being claimed by the unpaid party. Now, even if you have a set-off of a counterclaim that is more than the payment claim amount, at the end of the day, even if you win, you can only zeroize the claim. In CIPAA, it is very pro-claimants, unfortunately. It is pro-contractors, it is pro-consultants, it is pro-subcontractors. So if you have a counterclaim that is more than the claim in the payment claim, that unfortunately, you can only zeroize the claim. You cannot get more than that. If you want to get more than that, then you have to start an arbitration. Now, the good thing is that if you win, you of course be compensated with the costs that you have incurred in defending the payment claim or in CIPAA. Again, when you serve the payment response, take cognizance of the service modes as set out in Section 38, which I've already elaborated earlier. Now, I've done my part in relation to payment claim and payment response. I'm going to pass the mic back to my partner, Hong Kit, to take on the second section, which is about the initiation of CIPAA under the CIPAA Act. Hongkit, over to you.
Thank you, Loon. Okay, so we will now look at how to initiate a CIPAA claim. Pursuant to Section 8 of CIPAA, a claimant may initiate an adjudication proceeding by serving a written notice of adjudication. I prepared a checklist as a reminder before the notice of adjudication is issued. First and foremost, whether a payment claim was served. You can only refer a dispute arising from the payment claim. For instance, if the payment claim is about certificates 1, 2, 3, you cannot then include certificates 4, 5, 6 into the notice of adjudication. Second, whether the 10 working days for the respondent to serve a payment response has expired. Bear in mind the calculation of working days is depending on the location of the project site. If the project is located, say, in Johor or Kedah, Sunday is then a working day. If the notice of adjudication is served early, the entire CIPAA claim will be rendered premature. Third, pursuant to the Section 7.3 of CIPAA, a dispute referred to adjudication is subject to the Limitation Act. So you must also check whether the claim is time-bound or not. Now, after satisfying yourself with the items on the checklist, you can now proceed to commence and register the CIPAA proceeding. The rules and procedure for this have been set out in Rule 2 of AISC Rules and Procedure. These rules, you can find them on the internet or the small booklet distributed by AISC. Now, the claimant will have to first serve a notice of adjudication, also called Form 3, on the respondent, and follow up with a notice to the Director of AIAC, Form 3A, together with a non-refundable registration fee of 265 ringgit. So once AIC receives Form 3 together with the Form 3, your CIPAA case is now considered registered. In this process, the common problems encountered by us is that the respondent refuses to receive the documents or refuses to acknowledge receipt with its company stamp. If the respondent refuses to accept the document, what you can do is leave the document at the respondent's office during normal business hours, and perhaps take a photo with your phone as the evidence of delivery. Also, just to be safe, you may also want to resend the whole document by AR register post, which is a mode of services under Section 38 of CIPAA. If a different company stamp is used or you call CHOP on the notice of adjudication, don't worry. As long as you deliver to the correct address, the document is deemed served under Section 38. Now, after registering your case, you want to have an adjudicator come on board for your case. Under Section 21, the appointment of the adjudicator can be made by the agreement of the parties or by the Director of AISC when there is no agreement between the parties. It means neither of the party can unilaterally pick their own preferable adjudicator. So Rule 3 of AISC Adjudication Rules and Procedure set out the procedure for the appointment. If the parties cannot agree an adjudicator within 10 working days from the service of the notice of adjudication, either party can request the Director of AISC to appoint an adjudicator. This notice is called Form 5. It must be submitted together with an administrative fee of 424 ringgit. After receiving the Form 5, AIC would have to appoint an adjudicator within 5 working days. And the appointed adjudicator must indicate his acceptance of the appointment within 10 working days. But before that, he has to negotiate his terms of appointment, including his fees with the parties. The parties are free to agree any fee with the adjudicator, but there are currently 2 sets of fee available for reference, the standard fee and the higher AISC recommended fee. You can get these 2 tables on AISC website. If you go to AISC website, there's actually a fee calculator to work out the total adjudication fee for you. See? You just put your dispute amount, then the adjudication fee and respectively the total fee will be compiled. So after the terms and fees are agreed, the adjudicator will have to issue a Form 6, the notice of acceptance of appointment to act as the adjudicator. It's a long name for the form, to indicate his acceptance of the appointment. Once Form 6 is issued, the appointment process is completed and the timeline set out in Section 9 of CIPAA for the claimant to serve the adjudication claim will kick in. The common problems encountered in this process are the respondent is silent or not participating at all, and also the adjudicator sometimes fails to issue Form 6 within the 10 working day period. For the first problem, it does not matter even if the respondent is not participating. The appointment process will go on somehow. For the second problem, however, this is a serious problem. If the adjudicator fails to issue a Form 6 within the period, his or her appointment is invalid. You will have to immediately inform AIAC case counsel, and most likely AIAC will require you to reissue a fresh Form 5 to repeat the appointment process. I'm done here with the initiating process. I will now pass the mic back to Loon. Loon, over to you.
Thank you, Hong Kit. Now, I have talked about payment claim and payment response, which are the initial steps before the commencement of CIPAA proceedings. And Hong Kit has actually touched on the procedure and the steps that you need to go through for the commencement of the adjudication. And once the adjudication has been commenced, you need a third-party person who is the adjudicator to be appointed to adjudicate your dispute. And once that's done, of course, the challenge comes in for the parties and also for the adjudicator as well. Now, from the adjudicator's perspective, there are two issues which he or she will usually struggle. Now, one of which is actually adjudicator's jurisdiction. Now, one of the parties, usually the respondent, will raise the issue that the adjudicator actually does not have the jurisdiction to adjudicate the matter. And when the adjudicator faced with such a situation, how is he going to deal with it? Now, most of the adjudicators will take an easy way out. They will refer to Section 27, Sub 3. It says that notwithstanding the jurisdictional objection, he has the right and the power to proceed with the adjudication proceedings. If the party is unhappy with it, then they can actually take up the matter to the High Court later. Now, so that would be one of the options. It's not wrong, but it's important to note a case called Ramo Industries. It was decided by Justice Lee Swee Sing before he was elevated to become the Court of Appeal judge. It is an interesting case, and he decided in that matter, whereby the adjudicator, actually I was the adjudicator in that case, and the decision was actually upheld. Now, what happened is that the party raised an adjudication jurisdiction. The contracting parties was one, Ramo Industries, Sdn Bhd, and then with another party in Malaysia. Now, what happened is that the Malaysian party then launched a CIPAA claim against Ramo Industries Malaysia. Now, during the proceedings, Ramo Industries Singapore actually came in to say that they are the actual party, not Ramo Industries Malaysia. The actual party is actually Ramo Industries Singapore, because after the contract had been entered, there was another agreement entered with the Ramos Industries Singapore entity to say that payment would come from Singapore and not from Ramo Industries Sdn Bhd. Now, having gone through this purchase orders and unclear contracts, and I gave an interpretation to say that firstly, I acknowledge that I do not have the jurisdiction to decide on my own jurisdiction, but I have made some observation. The reason I made the observation is to satisfy myself that this is not a clear-cut case to say that I have no jurisdiction. If I am satisfied that it's a clear-cut case that I have no jurisdiction, what I will do is that I will resign. But because in this case, I found that it is not a clear-cut case, and I've made factual observations that what happened is that the contract with Singapore entity was just a payment arrangement. The main principal contract with the Malaysian entity still remains intact. So I have gone through the fine prints of those contracts, and I've made a conclusion. I just leave it at that, and I continue to deal with the merits. I rendered the award, And Ramo Industries Malaysia then tried to set it aside. The High Court, having gone through the same facts that I did, he decided to say that I had the jurisdiction and I was correct. So in that case also, the judge made an observation. Although the adjudicator does not have the jurisdiction to deal with his own jurisdiction, but his observation on this issue would eventually help the court to decide on the matter. Although the decision is not binding, but it would help the court to see the case more clearly. Now, that is actually one of the experiences that I have encountered that perhaps those adjudicators out there should consider, rather than just taking an easy way out by quoting Section 27 sub 3, but to take note whether it is a clear-cut case or not. If it is a clear-cut case, you have a choice, and that is to resign. Next slide, please. Now, of course, the other difficulty that the adjudicator would have to grapple with is actually the powers, the wide powers given to him under Section 25. If you know about Section 25, there is a list of powers given to adjudicator, and the powers are wide in nature. But having said that, it is actually not a carte blanche. It is not like you can exercise your power the way you like. You can only exercise the power within the parameters of the law, within the rules of natural justice. After all, it's about procedural fairness. Even though CIPAA procedure is rough, it doesn't mean it tolerates flagrant disregard of the principle of natural justice. So the adjudicator must bear in mind, with the wide power, they will have to exercise it within the parameters of the law. One of the issues is that whether there should be a hearing or no hearing. Now, the reason why I say this is that before, the court has said that this is solely within the power of the adjudicator. If the adjudicator doesn't want to hold a hearing, even if there is a request from the party, that's the end of it. You cannot challenge it later. But there is a Court of Appeal decision last year, which says that the adjudicator, having denied a party's request for holding a hearing for the expert evidence to be tested, that amounted to a breach of natural justice. But of course, having said that, the court had cautioned and also made a remark to say that not every case is the same. It is because in that case, the adjudicator had ample time. He should have given the opportunity to the parties to address that issue and allow the other party to tender expert evidence to counter the expert report that has been tendered late in stage. So it actually depends on the circumstances of the case, but bear in mind, do not think that you have the absolute power. In certain circumstances, if you think that you should and you can hold a hearing, in the abundance of caution, just do it. Now, the other thing is about the admission of new evidence tendered at late stage. It is like ambush. Now, you see, the respondent always view that the claimant is always ambushing them. So they would also like to ambush them by holding everything till the last stage at the adjudication response and only tender all the evidence and the expert reports with 100 pages, 200 pages, and sometimes 500 pages with 20 or 40 boxes of documents sent to the claimant, whereupon the claimant only has 5 working days to respond within the set timeline of the act. So what do you do with it if you are the adjudicator in that kind of situation? Again, it is very risky for you just to disregard those documents. What you can do, first thing, is that you might want to ask the parties for an extension of time for you to deal with the matter. Because of the voluminous documents, there's a duty for you to deal with it. You have to deal with it fairly, and equal treatment must be given to the parties. So if the claimant wants to ask for an extension of time in that special scenario, you should, I think, give an extension of time so that they would also be properly prepared, and you will also be properly appraised, because you do not want to be left with such voluminous documents. It's risky for you to disregard it because they would actually raise a breach of natural justice challenge later. If you admit it, you do not know how to deal with it without a response from the claimant. So the best thing is to allow an extension of time to the claimant to deal with the matter. Even though it's 1 month or 2 months, it doesn't matter. depends again on the circumstances. Take the safer route rather than just taking an easy way out, disregarding it, and then makes it very difficult for the lawyer to defend your decision later. Now, that I have already dealt with the EOT for filing and submissions. It's solely within your power, so long that you give reasons. It is a procedural decision to grant an extension of time to file documents, and it is difficult for the parties to challenge that decision. Final claim, it has been settled. You can now file a final claim, payment claim in CIPAA. There were some uncertainties, but after Martego decision in the federal court, it is confirmed now that you can launch a payment claim based on final claim or final account. Loss and expense is also permissible already, so then there's actually no issue about that. But the only catch is that loss and expense claims must be expressly allowed under the contract. If there is no express provision allowing loss and expense under the contract, then you cannot launch a loss and expense CIPAA claim under CIPAA. Now, non-certified claims, definitely you can. I've received this queries time and again, just because that the architect or whoever certifier has failed to issue a certified payment. That's not a hindrance. You can still launch a claim based on your payment application, so long that the timeline for them to certify has already passed. If there is no timeline for certification to be done by the SO or the contract administrator or the architect, then Section 36 will come to your to save you. It says that payment will be due within 30 days upon the filing of the payment application or invoice. Sorry, upon the service, not filing, upon the service of the payment application or the invoice. Now, the other thing is under certified claims. Again, this one is also settled under certified claims. There is a MRCB decision in the Court of Appeal, which has already been upheld by the federal court last year, which says that under certified claims is also included as part of adjudication. Now, I've done with the processes and the powers and jurisdiction. I'm going to pass the mic back to Hong Kit to finish the fourth section, which is the delivery of decision and the aftermath.
Thank you, Loon. Right. So now, consider you have gone through the whole proceedings. You have won the adjudication. Congratulations. So what do you do when you receive an adjudication decision? Of course, scroll to the last page to see if it's a winning or losing decision. If it wins, then call for a celebration party. But hold on a minute. Before booking as the celebration party is actually much more than that. Remember, to win is one thing, and to receive payment is another. You may win a CIPAA claim, but may still not be able to receive any payment. So when you receive the adjudication decision, first thing to consider is that whether the adjudication decision is delivered within the timeline stated under Section 12. If it's not, the adjudication decision is void. It means that even if you have won, you still have to probably restart the whole proceedings all over again. Also, you have to read through the entire adjudication decision to see if there is any computational or typographical error. If there is, you may want to request the adjudicator to correct it. But bear in mind, only computational and typographical error can be corrected. The adjudicator cannot be asked to change his decision or any substantial part of the decision. Now, pursuant to Section 13 of CIPAA, an adjudication decision is binding unless it is set aside by the High Court or the subject matter of the decision is settled by a written agreement or the dispute is finally decided by arbitration or court litigation. If none of that happens, when the losing party refuses to pay the sum to pay under the sum under the adjudication decision, the Act provides a remedy to the winning party, which will now I will go through with you. First, the winning party can enforce the adjudication decision pursuant to Section 28 at court. Once the adjudication decision is enforced, a judgment or court order of the High Court will be obtained by the winning party. The winning party can then execute the judgment or order against the losing party. Then, Generally, a contractor cannot suspend work or slow down even when payment has not been made, unless the terms of contract clearly should allow that. Section 29 of CIPAA gives the winning party the right to do this when the adjudicated sum has not been made in full. So the winning party who triggers Section 29 to suspend or slow down his work is not in breach of contract, and is also entitled to extension of time and loss and expense incurred. And this is not all. We will now look at direct payment from principal under Section 30. Likewise, generally speaking, a subcontractor who does not have privity of contract with the employer has no right to seek direct payment from the employer. Section 30 gives the winning subcontractor the right to request for direct payment for the adjudicated sum from the employer. Now, this does not mean that the subcontractor can demand the adjudicated sum from the employer as if the employer is the main contractor. To succeed under Section 30, they must be payment due and owing by the employer to the main contractor at the time the direct payment request is made by the winning subcontractor. Sorry. So we have gone through sections 28, 29, and 30. They all sound like an attractive option, right? So the good news is that you don't have to choose which one to exercise because Section 31 allows the winning party to exercise all remedies concurrently. This means a winning subcontractor, just for example, can simultaneously suspend work, request for direct payment from the employer, and also bring the main contractor to court for enforcement proceeding. Now, still not the time for the celebration yet. We still have to consider what the losing party can do. The losing party can apply to the court to set aside the decision under Section 15. And as you can see here, there are 4 grounds for set aside. If the losing party successfully set aside the adjudication decision, the entire adjudication proceeding will be treated as if it had never happened. The parties can re-adjudicate the subject matter. Now, apart from set aside, the losing party can also apply for stay under Section 16 for the 2 circumstances on the screen. If the losing party's stay application is allowed by the High Court, the winning party will be unable to exercise any of the remedies mentioned earlier, pending set aside, arbitration, or court's proceedings. Okay, thank you. That's all from me. I will now pass the mic back to Loon.
We still have a little bit time for us to address some of the questions raised by the audience. Now, I have noticed that is an interesting question. The question is this: can we claim for late payment interest under clause 30.17 of the PAM Form Contract 2006? Now, as you know that in PAM 2006, there's a provision allowing for late payment interest. If there is a certified sum which is not paid within time, then the contractor can actually claim for late payment interest as set out at the rate set out in clause 30.17 of PAM form. Now, this issue has already been decided in the case of Macro Resources by Justice Lee as well. He said that this is by and connected with the construction claim, and therefore it falls under the parameters of CIPAA, and the claimant contractor can actually claim because it's actually provided for under the contract. In any event, in clause 25 of CIPAA, the power is given or conferred upon the adjudicator to award financing cost and interest as well. So that is a non-issue now. It's been settled. Yes, the answer is yes to your question. You can claim for late payment interest that is allowed for under clause 30.17 of PAM Form 2006. Now, Hong Kit, do you have any questions you would like to answer?
Yeah, I would like to pick up one question from the audience here. The question is this: can the adjudicator suspend the adjudication decision until the advance payment is deposited with AIAC? Generally, the adjudicator cannot suspend the adjudication proceeding. The proceeding have to carry on because the payment of the advance payment is not a condition for the adjudicator to proceed with the proceeding. However, the adjudicator can withhold the adjudication pending the advance payment, meaning the decision still have to be released, but probably to AIAC only, not to the parties. And until the parties paid or make the advance payment to AIAC, AIAC will inform the adjudicator, and then the adjudicator will release the decision. That's all from me, Wailun.
Okay, I think that's the end for the session. It's already 11:41. Thank you very much again to all the audience here today for spending the time Sunday morning with us, learning about CIPAA and sharing knowledge as well. We will see you again tomorrow, same time, 11 o'clock on another topic. So, Hong Kit, do you have anything else to say?
Yeah. So thank you again for your support. It's a good turnout even for Sunday morning. So as you can see on the screen, we have started lining up new series for the weeks to come. Stay tuned with us. Check our sign up page for updates. I also would like to remind the audience we have an evening session today at 3 p.m. We will have 3 very experienced and reputable consultants coming up as our guests to share their views on consultants' integrity. So join us later if you can. Thank you again. Enjoy the rest of your Sunday. Goodbye. Thank you, Wailun.
Thanks, Hong Kit.
See you again.